better nostalgia could we get than by celebrating this year the 10th birthday of the much loved stroke loathed case of Denton and T.H. White. What we're going to talk about briefly in the case today is the procedural history, very briefly, that led us up to Denton, and then some of the more recent appellate authorities governing how we handle relief from sanctions applications in practice now. So the new approach to relief from sanctions started with the Jackson reforms, and I've set out there the wording that remains in the CPR, and the addition that came in relation to relief from sanctions was 3.912, which the court also had to actively take into account enforcement of compliance with rules, practice directions, and orders. What you will see from paragraph 4 of my talk is that the rather quaint aim behind this rule was to try and reduce the amount of satellite litigation in relation to applying for extensions of time and other such matters. The change of the rules was quickly followed by Mitchell, which I've set out paragraph 5 in my handout. And Mitchell took a fairly strict approach to relief from sanctions back in the quaint days when being rude to a police officer was a resignation matter for a cabinet minister. What Mitchell effectively said was that although all of the circumstances of the case to be taken into account, of particular importance was the need for litigation to be conducted efficiently and at proportionate cost, and for enforcing compliance with rules, court orders, and practice directions. Those of you who were practicing at that time will remember in the immediate aftermath of Mitchell how difficult it became just to obtain an application for relief from sanctions. Almost impossible. So much so that the Court of Appeal went back and re-looked at it in Denton. And of course, in that very Court of Appeal way that they have, they said, no. You were all wrong in your interpretation of Mitchell. We weren't wrong in our judgment, but here's a completely new way of doing things. And what they introduced was the 3-stage test that we still apply now. So the court has to look at what is how serious or significant is the breach. The court has to identify the reason for the breach, and they then have to go on and consider all the circumstances of the case. In particular, what the Court of Appeal in Denton and in a couple of authorities that followed shortly after that stressed was, unlike the approach that those of us who'd been getting Mitchell wrong had been taking, you shouldn't take opportunistic approaches to opposing applications for relief from sanction. Instead, we should all cooperate and work together very nicely. So that's a brief bit of nostalgia, looking back at the history. Let's look now at some of the more recent case law. And I've tried to address these cases in the order that the court will assess the questions, so starting with seriousness of the breach. The first authority is Phipps and Goldburn, which is a 2024 High Court case. And this was where the claimant had issued a claim but had failed to serve his claim form. This resulted in an unless order. The claimant had been in breach of the unless order and not filed the claim form, and instead applied to the High Court for relief from sanctions. Funnily enough, breach of an unless order is still considered to be a serious and significant breach. What the High Court said, that if they were to grant relief, it would be to drive a coach and horses through the unless order and refuse to grant relief. On the contrasting scale of seriousness, we have Maninaro and Persons Unknown and others. This was in the terrifying world of cryptocurrency fraud. of which I'm nowhere near qualified enough to speak about, save for analysing the relief from sanctions conclusions we can draw from it. In this case, the claimant was only a few hours late in serving the defendants with his claim form. And in this case, the High Court granted relief, accepting that the breach was neither serious nor significant. One of the factors that they'd taken into account in this case was that 2 of the 5 defendants had not engaged in any way in the proceedings, and so the court felt that they were unlikely to respond to the claim form in any event, even if they'd been served with it in time. So there was no prejudice to the defendants. It wasn't a serious breach. Relief was granted. Next up is Seaton Management and Evans Jones, which is a 2024 High Court decision. This was in relation to an application to restrain, for an injunction to restrain presentation of a winding up petition. The respondent was ordered to file and serve witness evidence in response to the application and filed the witness evidence about a month late. The High Court found that it was a serious and significant breach, and of particular consideration when weighing up seriousness and significance was the fact that it had a serious impact on the trial timetable, and that in particular, injunctions to restrain presentation of winding up petitions are supposed to be an efficient and summary process, and it would have caused an unreasonable delay to relief in that process. Lastly, on assessing serious, is the wonderfully named case of Kieran Looney. Although relief was granted in this case for a witness statement being filed 7 months late, it is a useful authority to bear in mind for when you're taking on that risky process of suing a litigant in person. What the High Court reiterated in Looney was that it would not be appropriate to apply a lower standard of compliance with rules orders to litigants in person, and that it is reasonable to expect that a litigant in person will familiarise yourself with the rules when conducting litigation. Those of you who have conducted litigation against litigants in person will know that that is not always the case. Moving on from seriousness of breach to reason for breach, I think this is my favourite case of all of them. ELO Trustees Limited and Bonhams, a 2023 Court of Appeal case. There was an application for relief from sanctions relating to the late issue of a claim form and the late service of a claim form. One of the reasons for the delay in issuing and serving the claim form was because the director, a sole director of ELO Trustees Limited, had a very unusual name. It's not a typo in the handout. His name was Mr. XXXX, that's 4 X's, ELO. The fact of his unusual surname made the court mistakenly think that this was a case that was suitable for an anonymity order. And so it took them a long time to issue the claim. Turns out having an unusual name is not a good reason for failing to comply with a court order. And what the Court of Appeal held, amongst other things, was that the applicant should have anticipated that his unusual name would have caused problems, and without any further would have caused problems without further explanation to the court where it was issued, and that in and of itself did not constitute a good reason for non-compliance. Bad news for Mr. Castlemaine. Next, Future Properties, Southeast Limited, and Favourite Restaurants. This was where the court determined that the alleged is very much in inverted commas, the alleged illness of the director of the company was not a good reason for non-compliance. This was in relation to an application for late allowing expert evidence. During the court's investigations, they discovered that whilst the sole director of the defendant had claimed he was too ill to deal with the court process, he had done a number of other things in the course of his role as a director, including, by himself, making a fairly complicated application to restore his company to the register. The court found that alleged illness was not a good reason and refused sanction. Next in the list of what's not a good reason is Tameside Caravans and Storage Limited and Via Vecto, a 2024 High Court case. This was a case where relief from sanctions was sought for application for permission to appeal out of time. One of the reasons that was the appellant cited for the delay in submitting their appeal was that they said it was too difficult for them to identify what the appropriate appeals centre was for them to send their appeal to. This resulted in him sending his appeal to the wrong court centre. The High Court, I think it was the High Court in Manchester, dealt with this and found, I think during the course of the case, pulled up on Google the list of appropriate appellate centres and demonstrated just how easy it was to find that, and made a finding that the rules and practice direction were very clear and accessible online, and that even a litigant in person ought to be able to find them. On that basis, the ignorance was not a good reason for granting relief from sanctions. Contrast that with the case in Tishenko and Hyde and others, which is a 2024 High Court case, where illness and other circumstances were a good reason for non-compliance. The non-compliance, this again an application for permission to appeal out of time. The delay in this case had been the appellant had been dealing with ongoing possession proceedings with young vulnerable children, and had also had a lengthy stint in hospital for ophthalmic surgery. Funnily enough, being in hospital having surgery is a good reason for non-compliance, so don't worry if your clients end up there. Last one, and one that should actually give pause to a number of people who rely heavily on IT, is Henderson and Jones and Stargunter Limited, which is a 2023 High Court case. This was a case in which relief from sanctions was sought for filing a cost budget out of time. Now, whilst relief was ultimately granted, it's important to note what the court's finding was in relation to good reason in this case, because what the defaulting party said to rely on was that they left their cost budget to the last minute and then their IT systems had failed, so they were unable to complete it on time. The High Court said clearly in that case, if you leave something to the last minute and your IT systems fail, that's on you, and it's not a good reason for granting relief from sanctions. Effectively saying, get a bit more organised. Lastly, all the circumstances of the case, and these are a bit longer because obviously they take more into account. There's the case of Tiernan Spratt and Wolverhampton City Council. This was a case where the claimant had been injured at work and claimed to have suffered a psychiatric injury at work, and issued a claim against the local authority employer for damages for personal injury and psychiatric harm. The claimant had indicated in his claim that the psychiatric stress that he'd suffered at work had caused him to re-experience symptoms of PTSD, which he'd incurred by being abused by a series of foster carers when he was a child. When the defendant obtained the psychiatric report found that, in fact, not only had he not been abused as a child, he'd also never been in foster care. A year after the close of the deadline for expert evidence, and for witness evidence, the council sought to obtain statements from family members of the alleged claimant who gave evidence to the effect that he'd never been in care at all and had lived quite a happy life at home. Despite the late service of those statements, what the High Court in Tiernan Spratt found was that it would be unjust for the court to have to consider such a fundamental and important issue of credibility without admitting witness statements on that point, particularly in a case where, because it was personal injury proceedings, fundamental dishonesty was alleged and there were going to be potential cost consequences and contempt consequences from it. The next of those cases that I talk about is Bellis and Sky House Construction. This was a case where the defendant had failed to file an acknowledgement of service and accompanying witness statement. The court found that although the breach was serious and there was no good reason for it, the practical effect of the default was minimal, and there'd been no prejudice caused to the claimant by the default. Of particular relevance in this case was the fact that the claimant had been fully aware of the grounds that the defendant was going to rely on, and they were fully aware of their intention to defend the claim. So in all those circumstances, it was found appropriate to grant relief. Lastly, and this is the last case I will take you to, is a rather unusual case of Cole and others and Howarth and others, which is a 2022 High Court case. This was where a case had been struck out for non-payment of a trial fee. And an application for relief from sanctions had been made, and the court found that the breach was serious and went as far as to describe in its judgment the breach as inexcusable, but then relying on all the circumstances of the case test, found that if the trial didn't take place on this occasion, a number of the same issues were going to be raised in other claims in a different court anyway, so we may as well have the trial now. Apparently the court found it was very important to both parties that the issues were resolved sooner rather than later, and that need for issues to be resolved, which I suppose could in theory apply to any case, was found to trump the seriousness nature of the breach and the lack of good reason. I will leave you at that. Find me afterwards if you've got any questions, or drop me an email, and thank you very much for listening.